Shipping Newsletter Legalseas. Welcome to our April edition of Legalseas, where we once again review a series of topical issues for the shipping industry. In this April edition, we have 5 articles which show the breadth of our shipping practice, covering the more unusual but vitally important shipping discipline of taxation and employment law alongside the more mainstream maritime matters. The first article, co-written by shipping dispute resolution partner Philip Roche and associate Peter Glover, addresses the legal aspect of the thorny issue of employing armed guard on board vessel. In circumstances where the number of vessels being attacked by pirates is increasing exponentially, ransom payments are rising, and there are considerable numbers of high-value mega yachts being ordered by persons who are likely to be very keen to avail themselves of additional security arrangements. This is clearly a relevant topic. You can also view a video of Peter Glover presenting this article. On a related subject, our second article, written by Shipping Dispute Resolution Associate Peter Glover, reviews the implication of the Court of Appeal's recent judgment affirming the High Court decision in Macefield AG versus Amlin Corporate Member Ltd, the Bunga Melati II. Regular readers of Legalseas will recall that the High Court landmark judgment in this case approved the shipping industry expectation that ransom payments were legal. To review our May 2010 article covering the High Court judgment in this case, our third article, written by tax partner Angela Savin, looks into the do's and don'ts relating to tax investigation, including dawn raid in the United Kingdom launched by Her Majesty's Revenue and Custom. HMRC. This article, which provides practical guidance in terms of a taxpayer's duty to cooperate with tax investigation, including safeguarding and providing to HMRC. A relevant document is the first in a series of articles we will include in Legalseas dealing with different legal aspects of tax investigation. Fourth article of this April edition relate to the proposed change to the Race Relation Act 1976 regarding seafarer. Employment partner Paul Griffin and know-how lawyer Claire Tarpon, who have been providing Legalseas reader with a regular update on this change, outline in this article the European Commission official views regarding the proposal to remove the exemption against discrimination on grounds of nationality in respect of seafarer pay. Our final article from Australian shipping and admiralty expert Ernie Van Buren, who practices in Northern Rose, Australia's Brisbane office, and senior associate Claire Poster, deal with the important topic of the availability of surrogate ship arrest for maritime claims in Australia in the light of the recent judgment in the Gem of Sevega case. Surrogate ship arrest provision of Australian maritime law, which has similarities to the well-used admiralty weapon of associated ship arrest in South Africa, contains quite restrictive provision relating to ownership of surrogate vessel, and parties looking to obtain security for maritime claims in Australia will need to pay particular attention to their due diligence if they are to be succeed in achieving and maintaining an arrest. As always, I hope that you will find our articles to be of the interest, and we will be delighted if readers could provide any comment on the content or suggestion for future articles of Legalseas. As many of you will be aware, Northern Rose Group will be opening in the coming months a new office in Hamburg, and we confidently predict that a series of German maritime articles will be forthcoming on Legalseas. Finally, in addition to the articles in this issue of Legalseas, you will be aware that we put out legal updaters on subject of interest. This can be found on our website, and as an example, we have recently produced updaters on the Ministry of Justice guidance on the UK Bribery Act and notes on two recent cases relating to time bars and public policy and the payment of ransom. Consequences of the radiation leaks from the Fukushima reactor for the shipping industry is included in this April edition of Legalseas. If you have any difficulty accessing this or any other information, or you would like to retrieve these updaters directly, please contact the editor. Certain crime attack the label of international crime. Arguably, the first such crime to be recognized as such was the ancient scourge of piracy. In international law, pirates have long been categorized as hostes humani generis, enemies of the human race. As enemies of the human race, the requirement to fight piracy is one of the oldest constructs in international law. Today, the business of piracy is alive, geographically spreading, and despite the high personal risk to those who engage in the crime, profitable. The first successful pirate attack in 2011 took place during the afternoon of 1 January when the Maritime Security Center, Horn of Africa, detected the distress signal from the MV Blida. Since the taking of amphiblida, attacks on merchant ships have been occurring at a rate of more than one per day. In 2010, there were 219 recorded attacks on merchant ships compared with only 35 in 2005. The business model for Somali piracy is simple but effective. Pirate hijack the targeted ship with a view of to extortion. Today, ransom have long surpassed the traditional motive for piracy, that of conventional robbery. The total value of ransom paid in 2010 amounted to some $238 million or some $4.5 million per ship release compared with only $150,000 in 2005. In November 2010, the Semho Dream, captured earlier in April, established a new record for ransom payment when it was released for a reported $9.5 million. With pirates increasingly being able to operate a considerable distance far from their home shores, the risk of attack continues to escalate. Today, Somali pirate alone holds some 33 ships and 758 hostage captive, and with some 20% of the world commercial shipping making the 500-mile passage through the Gulf of Aden, these figures are only likely to escalate. The solution: there is little dissent from the international community as to the solution. Somalia is widely recognized as a failed state, and if there is to be a solution, it lies in fixing the lawlessness that has come to dominate the shattered state.